Chief Justice, Justices of the Court, good morning. This appeal is about the limits of judicial review. The compelling question in this case is, when is a religious membership decision justiciable? The appellant's position is that religious doctrine, including their process, is not justiciable. To decide this case, appellants submit that this court must first look at the decision maker and then look at the effect of the decision. If the decision maker is a private voluntary association, as in this case, not a public decision maker, the court door to judicial review is closed. But two other doors may open depending on the effect of the decision.
Excuse me to interrupt you at this time, but is it your submission that there is only one set of rules in judicial review, one for any private organizations, whether it's religious or not, or is there, into your submission, a different set of rules, different scheme for religious organization?
Our submission, Justice Wagner, is judicial review is limited to public decision makers. And the congregation, Highwood congregation, is not a public decision maker. It's a private body. And as the Court of Appeal in Alberta found in Knox, there are private remedies that would be appropriate in that circumstance. Private law would apply. And just if I can just add, excuse me, Justice Brown, I would just add, Justice Gascon, that Justice Wagner, that the congregation does not believe that they're above the law, that just because they are a religious organization, the law does not apply to them.
I wonder if you're stating the issue a little bit too generally. I wonder if there are really two issues here: is whether judicial review applies, and I understand your submissions from having read the factum that you're not a public actor, there's no contractual or property right at stake here, there's no statute, there's no agreement. So no judicial review. That's how I essentially understand the tenor of your submissions. But then there's a second question that even if it were judicially reviewable, is the question of the validity of the expulsion of Mr. Wall from the congregation justiciable. Is that a more correct characterization, or is it really, does it fall under the rubric of judicial review?
What you enunciate, Justice Brown, is the respondent's position, that there is some kind of a procedural review, a jurisdiction under an implied contract, in which case the court would have jurisdiction to review the decision of any private voluntary organization.
But I wondered if your position prevailed, if they didn't succeed on the point of this procedural review notion, that would you then plant your flag and say, well, it's still not a justiciable question? Is that a distinct question from the judicial reviewability of the matter?
Yes, it is,
okay,
Justice Brown.
All
I agree. And the reason being that this is a religious organization and the decision is a religious one. That's what makes this particular decision not justiciable, falling out of the judicial review regime in place to review decisions of public decision makers.
Okay, thank you.